Thank you to the organisers of the St Petersburg Legal Forum for giving me the opportunity to open this panel discussing London as a forum for disputes. My name is Stefani Boyce, and I'm the President of the Law Society of England and Wales, the professional body that represents more than 200,000 solicitors in our jurisdiction. Our purpose is to be the voice of solicitors, to drive excellence in the profession, and to be a valued and trusted partner representing, promoting and supporting solicitors. England and Wales, and particularly London, is a global legal centre. This has come about for a multitude of reasons: the utility of our law, the reputation of our judiciary, and the excellence of our profession are but a few. But it is important to recognise that we don't work in isolation. We are a global legal centre because there is a global legal centre community that recognises the advantages of conducting legal business in England and Wales. Those operating in our jurisdiction, many of which are foreign nationals, collaborate with overseas colleagues and firms on complex commercial transactions, helping to ensure investments are structured to be safe, viable, and add value. We are incredibly lucky to have such a diverse and dynamic community, able and willing to operate from England and Wales and across the world. London is home to lawyers from nearly 100 jurisdictions and hosts over 200 foreign law firms, many of which have developed capabilities in both English law and the law of other jurisdictions. The concentration of legal and financial services in London is a key factor to the UK's economic prosperity. London currently hosts 87 of the world's top 100 law firms ranked by 2016 revenue, and 5 of the top 10 global law firms are headquartered in the City of London. For foreign law firms, the English and Welsh legal system is one of the world's most supportive for business. It is a very open jurisdiction that allows virtually unrestricted commercial access. It is the jurisdiction of choice for conflict resolution in many issues, even when the matter has no connection to the region. Businesses use English law as it is flexible, predictable, and stable. It allows businesses and individuals to tailor their contracts to fit their specific needs, offering commercial flexibility. We also have a strong and reliable justice system with an experienced, skilled, well-respected and independent judiciary who are renowned for their understanding of the commercial world and for the reliability of their decisions. London provides a neutral forum in which to determine disputes between non-English parties. London is often chosen as the seat of arbitration for disputes between parties of different nationalities because it is perceived as being a neutral forum. Arbitration in London is confidential and informal, and we know that arbitration is particularly appropriate where the parties wish to have their disputes resolved privately, thus maintaining the confidentiality of sensitive commercial information, rather than it being in a public arena. In November this year, the Law Society will be hosting Russian Law Week in London, where I look forward to welcoming as many of you as possible to discuss the benefits of English law and London as a forum for disputes. Thank you, and I hope you enjoy the panel.